Hello, guys. This is Samuel Tombwen, a student of the College of Science, Engineering, and Technology in the Grand Canyon University. This is a presentation for the course CYB 630-0500, Enterprise Cyber Law and Compliance Strategies. The instructor is Dr. Jean-Pierre Nziga, and the date of today is September 11, 2024. So let's just head on to the first slide. So this assignment is talking about the FIPP. So the Fair Information Practice Principles are a set of privacy principles regarding data usage, collection, and privacy. These principles serve as a framework for privacy protection and information handling. They were published in 1980 by the Organization for Economic Cooperation and Development, OECD, and a number of countries agreed this principle this principle. That's according to Cloudflare 2024. That's a typo there, correct that. These principles continue to be relevant and influential today, although they are officially part of they are not officially part of any privacy legislation. So even though these principles were laid down in 1980 by the OECD, and they are not officially part of any privacy legislation, they are still relevant and influential today. They are the foundation, the base for many companies that are developing their own privacy policies when it comes to personal information, personal identifier information, or PII protection. So let's look at these principles. We have about seven or so of them. So the first one is transparency. So this policy requires agencies to be transparent about information policies and practices with respect to personal identifiable information, or PII, and should provide clear and accessible notice regarding creation, collection, use, processing, usage, processing, storage, maintenance, dissemination, and disclosure of PII. So PII here stands for personal identifiable information. That's information such as your maybe your social security number, your identity card number. Yeah, that's a personal identifier and identifiable information. And this principle of the FIPPS actually requires an organization or an agency to be transparent about information policies and practices with respect to personal identifiable information. So the next policy is individual participation. So this is a very good one. The individual participation policy requires agency to involve the individual in the process of using PII, and to the extent practicable, seek individual consent for the creation, collection, use, procession, or processing, storage, maintenance, dissemination, or disclosure of PII. Agencies should also establish procedures to receive and address individuals' privacy-related complaints and inquiries. So it requires the agency to involve the individual in the processes of obtaining and the usage of PII. So the next principle is purpose specification. So this principle, the purpose for which a PII is collected should be specified not later than at the time of data collection, and the subsequent use limited to the fulfillment of those purposes or such orders as are compatible with those purposes and as are specified on each occasion of change of purpose. Okay, so let's just talk about this. So the purpose specification, um, when you collect this principle requires an agency to have a purpose for collecting the PII, and this purpose should be stated not after when PII is collected. It should be specified before it is collected, and then the time of data collection and the subsequent use should be limited to the fulfillment of those purposes. Think that is a good one right there. So use limitation. This principle requires that personal data should not be disclosed, made available, or otherwise used for purposes other than those specified in accordance with the purpose specification principle, except A, with the consent of the data subject, or B, by the authority of law. So agencies are not allowed to use this PII above the purpose that was specified in the principle above, except in a situation where the data subject, the person whose PII was collected, has given consent or by the authority of law, say there is a court order to use the PII above the purpose of specification. So the next principle is data minimization. Organizations should only create, collect, use, process, store, maintain, disseminate, or disclose PII that is directly relevant and necessary to accomplish a legally authorized purpose, and should only maintain PII for as long as necessary to accomplish the purpose. If you look at all of this, it's really drifting towards scope, right? Towards scope, what you can do with what, how you can do it, and what you should not do. So let's look at the next slide, which talks about understanding the FIPPS, so continuation. So data quality and integrity is one of the principles too. The creation, collection, usage, processing, storage, maintenance, dissemination, or disclosure of PII should be done with such accuracy, relevance, timeliness, and completeness as as it is reasonably necessary to ensure fairness to the individual. Another typo that I have to correct that. And then security. Administrative, technical, and physical safeguards to protect PII should be established which commensurate with the risk and magnitude of the harm that would result from its unauthorized access, use, modification, loss, destruction, dissemination, or disclosure. So here it's just saying that administrative measures such as uh, giving orders for people not to trespass or get access to certain PII, technical such as doing access control, maybe doing two-factor authentication, physical such as putting barriers to protect PII. You can protect PII like in the DMV where they store physical driver's license or ID card. So these measures should be put in place to protect PII. Accountability and auditing. Agencies should be accountable for complying with these principles and applicable privacy requirements, and should appropriately monitor, audit, and document compliance. Agencies should also clearly define roles and responsibilities with respect to PII for all employees and contractors, and should provide appropriate training to all employees and contractors who have access to PII. So it's not just enough to have security, data quality, and integrity, and all of that, all of those good things. But now you have to be accountable. You have to also train employees on how to manage, how to, secure or the appropriate handling of PII. On to the next slide. Let's compare FIPPS with uh, with other privacy policies. We talk about other privacy laws and standards. So let's start with privacy policies. FIPPIS provide a broader conceptual framework for privacy protection that can be used by any organization in building policies, while privacy policies are specific documents created by organizations to align their privacy practices and commitment. Most of these are drawn from FIPPS. So FIPPS are just like the bedrock, the foundation, that they have guidelines, principles, those principles that we talked about earlier, that organizations can use to develop their private policies. Now, those private policies can be streamlined more than FIPPS are. So the next point is with FIPPS, fundamental principles such as transparency, individual control, purpose limitation, data minimization, security, and accountability, like we talked about earlier, are the main focus. Organizations use their privacy policies to try to address them. So organizations use the privacy policies, those policies that were drawn from FIPPS, to try to address these, principles. The other one is to ensure compliance with privacy best practices. Organizations' privacy policies often draw inspiration from FIPPS. Just like I said, they are the foundation, the bedrock. FIPPS provide general guidance, while privacy policies can provide more detailed information about how personal information is collected, used, stored, and shared by the organization. Take, for example, an organization has a policy that every information, PII, is shared through uh, uh, let's say, through encrypted email, right? So let's just assume that you're using Office 365 and they say every PII information should be shared through encrypted email. Now, that is a privacy policy of that organization. But what an FIPPS does is that it will give you guidelines on how to share PII. It won't tell you the exact way to share it. It won't tell you the exact tool to use, but it will tell you that use protected or secure tools. So privacy policies are typically tailored to the specific operations and needs of organization itself, as it takes into consideration industry standards and legal requirements. On the other hand, FIPPS are general in nature. Again, so let's compare FIPPS with privacy laws and regulation. FIPPS influence the development and implementation of privacy laws and regulations, as they serve as the foundational framework of such laws and regulations, just like we spoke about in the privacy policies. Many privacy laws and regulations use some or all of FIPPS as guiding principles to ensure compliance with recognized privacy best practices. So, FIPPS helps companies to be compliant to certain privacy laws and regulations. FIPPS are voluntary and based on organizations' commitment to privacy protection. Privacy laws and regulations provide regulations providing are regulation are laws and regulations that provide legally binding requirements and obligations that organizations must adhere to. So FIPPS are more voluntary, and based on organizations' commitment, but privacy laws and regulations are actually uh, uh, legally binded, and their requirements and obligations that organizations must adhere to. Privacy laws and regulations address different aspects such as data breach, notification, cross-border data transfers, and individual rights. FIPPS focus on general principles. So, looking at protecting identifiable information and putting the principle and putting the principles to use. So, these principles are the uh, principles of the FIPPS. So, as described above, these principles are designed to protect personally identifiable information. Federal agencies can put each of the principles to use by, let's talk about the first principle, transparency. When organizations are transparent about information policies with respect to PII, providing clear and accessible notices regarding creation, collection, use, processing, storage, maintenance, dissemination, and disclosure of said PII, the user is aware of what he his or her information is used for and to what extent. They are also given the choice to accept or deny the uses of such information. So let's look about the individual participation. Involving individuals in the process of using PII and seeking their consent to the extent possible on how to use PII gives the individual the information necessary to make decisions as to how he or she wants their information used or if they want it used at all. Federal agencies such as state police use this principle when they are obtaining information from a suspect, letting the suspect participate in the creation and collection of PII. So, take for example, there is a suspect, just say a burglary suspect, and the police is involved. They say you're detained and you know you're right. You can choose to talk to me now, or talk to me when you have your lawyer. And they say, "Do you want to talk?" And he or she says yes. So they ask, "Is his or her name?" And that is PII. So they involve the individual in the process of getting this information. So purpose specifications. Specifying the purpose of the creation, collection, usage, processing, storage, maintenance, dissemination, or disclosure of PII keeps agency working within an authorized scope of using PII. Scope, yeah. This principle can be useful to federal agencies such as U.S. Customs and Border Protection in getting exact PII and on a given subject. Use limitation. This practice protects an individual's PII because it limits what an agency can use it for, thereby reducing the chance of it being exposed. Following this principle, federal agencies such as state police can use this principle to manage the usage of PII collected from suspects so that it's not abused in the process of protecting the law. Data minimization. Again, this principle helps protect PII as only relevant and necessary data is created or used. This makes the attack surface smaller for hackers. Federal agencies can use this principle in creating sensitive PII in order to shield the PII of workers working on a risky or sensitive case. So let's continue with the protecting identifiable information and putting the principles to use. So data quality and integrity. This principle makes it easy for federal agencies to trust PII acquired from organizations that are PII are FIPP compliant. Also, it helps protect PII in that any change in the original quality can be spotted. These changes can be caused by hacking attempts. Security. Security is one of the key principles in data protection. Individuals can rest easily knowing that organizations are following this principle when it comes to the creation, collection, use, dissemination, and or disclosure of their PII. Federal agencies such as the Secret Service use this principle to protect very sensitive PII of top government officials. Accountability and auditing. When organizations are held responsible and accountable for the action, the creation, collection, usage, storage, dissemination, and or disclosure of PII, they feel a certain level of responsibility so that they take data security even more seriously. Federal agencies such as the Coast Guard can use this principle in making sure that all PII collected from individuals in certain areas are accounted for during auditing. So let's just talk about the first part of this last principle. So whenever an organization is aware that it's accountable or can be held responsible for the use or the misuse of PII, it puts in more security measures to protect that PII. So that is how this principle can be used or how it is useful for the individual. And the last slide is the principles of references. Thank you for watching, and I hope we all learned something here.